The religion, the state, and the law. For ages, the relationship between state and religion, and more particularly between the state and the church, has been studied. Nevertheless, thoughts about this relationship have changed through the years. For example, during the Middle Ages in Europe, the Christian religion determined the position of the state as well as the position of the church. Religion gave state authorities and state power its legitimacy, as the state itself would reflect those religions, and the government was the protector of the Christian faith. However, nowadays, religion is no longer that fundamental, as the starting points of democracy and the rule of law have started to emerge. Secondly, to compare the relationships between these aspects throughout. The relationship between state and religion differs from country to country. Different approaches often appear in the constitutions of this country. For example, Article 1 of the French Constitution determines the laic nature of the French state. The Establishment Clause in the First Amendment of the Constitution of the United States prohibits not only the existence of an established church, but also has a wider meaning. Article 140 of the German Constitution refers to some provisions of the Constitution of the Weimar Republic that on the one hand prohibits the existence of an established church, but on the other hand lays down that religious denominations may be recognized by the state. In English, of course, the Anglican Church is the established church. In the Netherlands, the separation of church and state is assumed to be unwritten principle of the constitutional law, as the basic law keeps silent on this issue. There are many spectrum of models between these relationships between the state and the law. The legislation and case law elaborate the relationship between state and religion in different countries. As a result, a very complicated picture arises. Therefore, comparative law studies often use models. This particular model, made by Winfried Brugger, for example, uses 6 different models. Firstly, that the state is completely opposed to religion. For example, in Albania, where in the 70s and 80s, religion was officially banned. Secondly, the wall of separation model, which is to be taken seriously not only in theory but in practice as well, as in they create a wall between the state and the religion itself. Thirdly, the separation and allowing for are linked. Government may neither advance nor obstruct religion. Fourth, they combine the separation with some kind of cooperation. In Germany, for example, where the government takes care of the church tax. Fifth, a more formal unity of state and church in the form of an established church. State and church still have different aims, however, respectively the citizen welfare and his salvation. In the last model, however, that difference has disappeared. The state and church actually converge as a theocracy. Religion has been a dominant force in the state domain. The question of whether government may use religious discourse raises, however, many controversies in many countries. The case law of the Supreme Court of the U.S. seems to be a rather diffuse compromise between the recognition of certain traditions, on the other hand, and stricter ideas about the separation of state and religion. Another example would be shortly after the French Revolution, crucifixes have disappeared from French courtrooms, signaling that they have banned any religious signs from courtrooms, thus separating them from acts of the state. In Germany, a conflict arose over the presence of a crucifix in a courtroom. The German Federal Constitutional Court judged the complaint, based on the right to freedom of religion, justified. If the crucifix is not removed, the individual would be wrongfully forced to conduct an action under the cross. In the Netherlands, no crucifixes are to be found in courtrooms. However, other traditional religious references do exist. The formula Vis Beatrix bis de grati Gods, or We Beatrix by the grace of gods, in the preamble of every act may serve as an example. Government in the religious domain. A second dimension of relationship between state and religion concerns the state task as far as religious matters are concerned. In the past, tensions between state and church were a regular phenomenon. As a result, governments were often inclined to interfere with the organizations of religious communities and with religious doctrine. Basically, it means that the government were often inclined and regularly interfere with the doings of religion, thus forcing their way into religious domains. For example, in England, the king as head of state formally is still the supreme governor of the Church of England. The Crown then has the power to appoint the bishops of the Church of England and power to approve certain church regulations. In Turkey, the Diyanet, the Directorate General for Religious Matters, not only appoints imams, but decides as well that respect for the state authorities and the army have to be represented as a religious duty, thus them blurring the lines between state obligations and religious obligations of that certain religion. Another aspect of government involvement with churches and religious communities might be in backing them financially. For example, in France, the government is the owner of many church buildings and puts these buildings at the disposal of religious communities. In Germany, the tax department collects the so-called church tax from the members of the denominations recognized under public law. Normal tax law sanctions apply. This church tax is an 8% surcharge above the tax on wages. In Belgium, since 1830, the government does not only pays the maintenance of church buildings, but priests, reverends, and rabbis to receive a state salary as well. State, religion, and social services. State and religion meet in society in the social and cultural domain. Of old, churches and religious communities have been involved in physical and mental health care and have supported the poor. For example, in France, after the Revolution, the healthcare was secularized, while at the same time, illnesses were treated on a more medical scientific basis. However, that organizations such as Catholic juvenile assistance organizations are excluded from financial support by the government. In the UK, a whole range of organizations is backed by the government, those including religious organizations. In Germany, freedom of religion by itself obliges the government to create enough space for this kind of organizations. Under positive Dutch law, the government has no strict obligations to give those tasks to private organizations. However, the government may not exclude organizations just because they have religious background. Still, it must be stressed that those organizations are supported because and only insofar they meet professional standards. Thus, their activities can be considered by the government to be in the public interest. State, religion, and education. For ages, churches and religious organizations have played a central role in the field of education. For example, in countries such as Germany, at least in certain states such as Länder, Christian values in some respects have maintained a positive position in public education. Lessons in religion, the substance of which is decided by the churches, are a normal part of the curriculum in a lot of public schools. In France, primary and secondary schools in the public education sector are obliged to ban all religious influences. In the United States, the wall of separation doctrine puts up a barrier for subsidies for private and secondary schools. So, in conclusion, in a pluralistic society, the state should not commit itself to a certain religion or philosophy of life. This is because that would suggest that a supreme being legitimizes a government authority. A neutral exercise of authority regarding religion in substance and appearance, on the other hand, does not exclude citizens. The counter-argument that government, by behaving so, chooses for an atheistic state but is not correct. A state has no conviction and is not comparable to an individual holding a conviction. Thus, ending my presentation on the relationship between the religion, the state, and the law. Thank you.